that is defective because under the statute 2151, as public officer, there is no reference there to presidential electors as being public officers, and therefore that should carry the day for us. The state's response says, well, not so fast, Mr. Gillen. We've got cases here that talk about situations in which 2151 doesn't carry the day and isn't.
Well, not even cases. I mean, the statute itself.
Right.
I mean, you're pulling that from the ethics statute.
Exactly.
So I'm not really sure why I would even look at that. I mean, public officers all throughout the code, and it's just kind of one of those hanging kind of question marks, I suppose.
So what the state does, and I can see the court's point. I'm not going to argue that. What I am going to say is that what they say, they cite cases where there are individuals that are impersonating agents, police officers, peace officers, or agents for Metro Atlanta Human Trafficking Task Force. Okay, that falls into that category. Trafficking in the task force or a federal agent. Those are things that the state responds to. I think that in the still motion, it covers some of the concerns the court may have regarding this issue of public officer and why we think that we should prevail on this as well. Again, hoping Mr. Beaver has his day.
Well, do me the favor. Actually, I've kind of put the still motions in a box and I haven't opened it yet. So make those arguments for me.
Well, I'm going to,
All right.
but not as articulately, I'm sure, as Tom could do it. But I'll give you the flavor. The flavor of it is that in the still motion, which we adopted as after it was filed, it talks about how other case law in Georgia, when it talks about, first of all, 1610-23 doesn't define public officer. So we start from that, so we've got that out there. Not defining the public officer. Now, but the still pleading does say that the issue of who is and is not a public officer is addressed in other contexts in Georgia law, usually in the quo merito proceedings where somebody's trying to find out the legitimacy of somebody having or holding a particular office. And in that context, there are cases citing in the still pleading that address this very matter. They cite Brown v. Scott and as a case in which the Brown v. Scott case, whether or not an individual has designation or title given to him by law or exercises functions concerning the public assigned to him by the law, they cite Brown. That doesn't, the inquiry doesn't really end there. The Georgia Supreme Court has noted the term public officer involves the idea of tenure, duration, fees, emoluments, and powers, as well as that of duty. And so that's McDuffie v. Ferguson, and that has to do really with grand jurors. So when someone says, well, is a grand juror a public officer? And the court breaks down an analysis talking about that, saying not really, because grand jurors may only meet for a few days. They're not essentially they're not there for some sort of duration or tenure. They don't take the same oath of office as prescribed for public officers, and they lack the element of tenure and duration which must exist to qualify as a public officer.
Okay.
Well,
so how would that apply again to like a purely fictional task force?
well, I mean, let's forget the purely fictional task force. It would let's have it that case law from our Supreme Court, how it applies to our case, and how it applies to our case is the presidential electors are not people who have lengthy tenure, duration, which it must exist. Frankly, their job is to meet for one day.
No, I see your framework there, but if the framework is actually in this, whereas the Metro Atlanta human trafficking course that doesn't even exist.
Well, it doesn't.
We
But
can't
someone
even
is
do this
pretending to
analysis of
be
tenure, fees,
someone is
history.
pretending to be an agent.
Maybe
And-
they're a part-time. I mean, it seems like if
Well,
you know what I mean?
we might agree to
Yeah.
disagree here, because I think that when someone says, well, I'm here's my badge. I'm an agent of enforcement of the law for, and then names a particular entity that doesn't even exist. They're pretending to be a peace officer. They're pretending to be an agent for the government, which by the very nature of that job would have tenure, would have responsibilities,
Yeah.
would fall into the definition that the Supreme Court has given in Brown v. Scott and McDuffie v. Pearson as to what a public officer should be. And so in that context, we have, and the same thing actually, and it popped up again on the issue in Morris v. Peters, another case, Supreme Court case dealing with whether or not someone is a public officer. That had to do with a quo warranto against the chairman of the Georgia Democratic Party and whether or not he would fall in as a public officer. Bottom lining it, like in that case, and which found that he was not, like grand jurors and public party officials, presidential electors are not public officials under Georgia law, especially for purposes of 161023. Their jobs, services are temporary, like the grand juries. Their position really only arises once every 4 years, is limited to a single meeting on a single day. So it lacks that element of tenure and duration which must exist. So it's kind of like back to the political case, Morris v. Peters case, which dealt with the state party political chairman, nominated in accordance with the rules of their party. But just because the fact that they were nominated by the rules of their party doesn't make them a public official. And like grand jurors, presidential electors they're not receiving their salaries for their service. So all of that, Your Honor, tells us that this particular count is flawed for the very purpose of these electors cannot be under Georgia law public officers. And so we although we agree with the court's initial position regarding the limitation on the definition of public officer in our pleading, good old Tom Beaver and the Still pleading has come forward to rescue us on that point. And so if you look at what they did, and hopefully Tom will do a better job of articulating those points, in their pleading, they talk about specifically some other cases that get into either in Texas and I think Utah as well, that deal more specifically with this. But for the purposes of argument today, I think that we've sort of got the drift on what I think is happening on the impersonation of public officers. They're not public officers, and clearly under the direction we believe of our Supreme Court, they could not be so judged. Now, again, I'm not going to spend a whole lot of time up here with the court, but I do want to touch on a few of the other components of our pleading. The forgery counts. Now, we indicated in those counts 10 and 16 are sufficient to dismissal. Writing a check in a fictitious name or a manner that the writing is made or altered purports to have been made by another person. That's the definition of 1610. We have what we have here in this indictment is we have an assertion that a writing or other than a check in a manner that the writing is made purports to be made by authority of the duly elected and qualified presidential electors from the state of Georgia who did not give such authority. Now, that's what they allege. Let's break that down as to why, and the state's response to us saying they want to focus on the phrase under the authority, and what we have here is the concept of what is the authority, who is this on October the 14th? Who was the duly, who's the duly elected and qualified presidential elector from the state of Georgia who did not give such authority on December the 14th, 2020? Now, the answer to that is that as a matter of law, simply as a matter of law, and we're going back, Your Honor, to some of the arguments we've made with the court earlier on the issue of supremacy clause, were worthy of at least highlighting some of those points to the court for the purpose of making our point here. And that is this, that, under the federal law, as it existed in 2020, when the state of Georgia failed to comply with federal law about having an adjudication of any pending controversy or litigation, and as we know, in the public record in this courthouse was the pending and unresolved Trump and Shafer litigation on the election. Now, because that lawsuit was not adjudicated pursuant to federal law, then the state of Georgia lost its ability on after Safe Harbor Day, lost its ability to then name who the electors should be. And as we discussed earlier, and I'll shorten the argument, but for the purpose of the record, I'll just make the following points. Once that happens, and it's very, very clear from federal law and from the language from Bush v. Gore, the state, any
Dissenting opinion in Bush v. Gore.
yeah, true. But as it points there, it's like, it's not, they see it as not even a serious issue, because the clear reading of the statute would say, if you don't get it done by Safe Harbor Day, then you have lost out. And once that happens, the power then shifts back to the Congress. So as of, by law, we think, not a factual issue, by law, on December the 14th, 2020, there were no duly elected and qualified presidential electors from the state of Georgia because of that failure. And
So understand your point, and I don't want to get too deep into it, but since we're in demurrer world here, wouldn't your allegation of whether a lawsuit was filed, whether it was pending, none of that's in the indictment? Doesn't that transform this into a speaking demurrer?
well, we don't think so, and the reason why we don't is the last time I think we quoted the court that the court could take a notice of the pleadings within the court system, and I believe that what we articulated there, and I don't think we had an objection from the state. Could be wrong, but my recollection is we didn't. That we then work from the framework of, yes, in this courthouse there was a filing, a pleading that we're not going. This isn't a speaking demurrer. It's a part of the court record. Part of the court record says there was a lawsuit that was not adjudicated by Safe Harbor Day. So we don't have to go outside the indictment. It's not a speaking demurrer. And because of that, by applying the law, these forgery counts, 10 and 16, in our view, must go. Now, the other counts that I would like to, or the other matter I'd like to discuss is the false statement component. And on the false statement counts,
Is that
of
14?
12, 18, and 40, dealing with false statement. Now, here, the issue here dealing with a false statement, for example, is when they're asserting that there was a document that was sent within the jurisdiction of the Office of the Georgia Secretary of State and the Office of the Governor of Georgia, departments and agencies of the government. Now, we've got two arguments to that. Number one, and again, back to Haley. Haley talks about this issue. And when Haley talks about it, the key thing is whether or not there was agency with the key phrase, with authority to act on it. Now, there are two flaws, the fatal flaws the state has as it relates to this issue concerning Haley v. State and on the issue concerning the safe harbor. One, as we mentioned, at that time, there was nothing for the state of Georgia to act upon. They merely received the information. It was merely a sort of a ministerial act, if you would. But even more fatal to their argument is the second argument that I made a moment ago, which I won't repeat other than referencing it. The failure to act by safe harbor date renders any activity on behalf of the state of Georgia, be it the governor or the secretary of state, renders that gone. Because now it's all gone back up to Washington, to Congress to deal with that. And the government in the state can't now say, or at any time say, well, we're saying that the Democratic nominees or the Democratic representatives for the electors, they ultimately became the duly elected. You don't do that. You don't parachute back into what happened on December the 14th. The world as we know it on December the 14th, there were neither Democrat or Republicans that were duly elected under federal law. And so given that, we believe that the false statement counts should go. Thank you, Your Honor.
All right. Okay, any thoughts from the state in reaction? Mr. Wooten, this one's yours.
Yes, Judge.
Why don't we pick it up on that last point, because I know we've dived into some of this, not so much the safe harbor aspect of it in that argument, but the idea that the governor's office and the secretary of state's office just didn't have jurisdiction. I know you've said that that's an issue of fact that needs to be proven, but isn't that also something that could be shown by as a matter of law potentially? And I know you don't agree to it, and so you can cover all that.
Sure. I don't agree that it's a matter of law. It is an issue of fact. And we've briefed this extensively and argued this before. We believe that even if it's not an issue of fact, even if the court were to consider it as a matter of law, we've given ample reasons why under statute, all of these entities have jurisdiction over many of the crimes that are alleged in the indictment, many of the topics all of the topics where we've alleged that some of these defendants have made false statements regarding. So I do maintain that I believe that it's an issue of fact for the jury to decide that we have to put up that evidence. We have to ask the GBI officers, what is your duty? What is your authority? What can you investigate? We have to ask the Secretary of State individuals while they're on the stand, what are your duties? What is your job? What do you do? Why are these things relevant? Why are these material to areas where you have jurisdiction to do something? What is your ability to act on these things? I think all of that has to come out at trial. And so as it relates to that argument, I think it's way premature. And anything that again, I always go back to the standard for what is a demurrer, right?
Right. But what I'm saying, just if there was a statute that explicitly, said that they didn't have jurisdiction, remind me, what is it that you're saying, just as a matter of law as a parent, that provides the governor authority over this after the safe harbor date?
Judge, I don't have the indictment in front of me, so I'd need to know specifically what statement we're talking. I think this is in regard to the
Sure.
The certificates or the paperwork where, if an elector doesn't show up on election day or on December 14th, that the governor has to ratify a replacement of that person. I think there were some documents that were delivered by Mr. Shafer and his co-conspirators to the governor's office, trying to get the governor to do that. That's provided by statute, that the governor is the one that has to ratify a replacement. So statutorily, he absolutely has the authority to act on that matter.
Okay. All right. So, but from the top, I think there was a lot of time spent on definition of public officer and some of the allegations raised in Mr. Still's briefing, which I think his motion deadline should be coming up soon. So if he's requesting argument, we'd have him in.
Sure.
But if you want to make any initial reactions, have at it.
Well-prepared judge.
All right.
First, I want to I've made this statement in the past as it relates to Mr. Shafer, and I'll make it again, which is we have to address an elephant in the room. The elephant in the room is that Mr. Shafer is in the 11th Circuit right now, demanding to be recognized as a federal officer. So what are we? I mean, are we saying that this position of elector is an officer or isn't? I think they need to make up their mind there. But as it relates to, well, I've actually got quite a bit of ground to cover, and I'll kind of take it as it was raised by Mr. Gillen. I want to start with, and again, as we pointed out in our response, we don't believe that the definition section in
I think he
21.5.3
as much
applies.
conceded that. So,
But Judge, if it did apply, I think it actually supports us. Because if you look at paragraph B, this is 21.5.3.22B, it says public officer means every other elected state official not listed in subparagraph A. So it's a comprehensive definition of any elected state official. So we believe that that would absolutely cover it to the extent that it's persuasive, that it shows that presidential electors are public officers. That definition says any elected state official. So they are elected state officials. I want to hit briefly on the cases that were raised by Mr. Gillen as it relates to what Mr. Still put in his pleadings, prepared to address those. First, there was an intimation that 1610.23 only applies to police officers or peace officers. We know that that's not true because of a case called Kennedy versus Carlton. That's 294 Georgia 576, 2014 Georgia Supreme Court case where a conviction was upheld for someone impersonating a DFAX employee, clearly not a police officer, a peace officer of any kind. So we can dispense with that argument. As it relates to the cases that Mr. Gillen referenced, the definition of public officer in other contexts, all of those cases deal with the definition of public officer in the context of a petition for quo warranto. I believe there's 3 cases that are referenced in Mr. Still's pleading. We're filing our response to that tomorrow, but I can kind of take them in turn. Mr. Gillen referenced this list of qualifications in the McDuffie case, tenure, emoluments, duties, et cetera. That's not the holding of McDuffie. So the way that the McDuffie case is structured is the Georgia Supreme Court says no one's ever definitively said what a public officer is in the context of quo warranto.
well, look, if you're about to file a response and Mr. Beaver may be requesting oral argument, why don't we just save it for when I've had a chance to read these cases and we can be more productive.
Sure, I can skip those cases,
Yeah.
but I did want to hit a few points, Judge, as it relates to the statutes that establish that presidential electors are public officers. First of all, the actual office itself is created by law. So it's created by the United States Constitution, Article 2, Section 1, Clause 2, and it's also created by OCGA 21-2-10 that actually establishes that there is an office of presidential elector in this state. They have duties that are established by law. Those are established both in the U.S. Constitution and the 12th Amendment, as well as at OCGA 21-2-11. By law, they're elected by the public, 21-2-10. And also there was a reference that they don't get a salary. That's actually not true. There's a compensation for presidential electors that is set forth by law at OCGA 21-2-13. Additionally, the election code itself refers to the office of presidential elector. It refers to it as an office. In 2 places in particular, 21-2-132A and 21-2-132E. And again, we again rely on those cases that Mr. Gillen discussed. Garrison versus the state, 276 Georgia App 243, 2005 case where someone was convicted for impersonating a federal agent, an unspecified federal agent, and that conviction was upheld by the Georgia Court of Appeals. Cert was denied by the Georgia Supreme Court. And then the Liberty case where they, of course, impersonate the Metro Atlanta Human Trafficking Task Force. that doesn't exist. So we would argue to the court that the definition for 161023's purposes, that our appellate courts have applied a very liberal definition as a public officer. It doesn't even have to be a real public officer, doesn't have to be a state officer, anything that purports to be, someone acting by authority of the government is a public officer. And that's certainly what presidential electors do. Their positions created by law, their duties are established by law. All right, so jumping down to the forgery counts. Again, elephant in the room. 1691, there's at least 5 ways that you can violate the forgery statute. The cases that Mr. Shafer relies on, Jackson versus the state, that's someone who is charged with forgery based on purporting a document purporting to have been made by another person. We did not charge under that provision of 1691. We charged under the final provision, which is by authority of one who did not give such authority. Mr. Gillen says that we didn't object to looking at these, things in the record in other cases. Let me be clear for the record, we do object. That's the definition of going outside of the indictment. So we agree with the court that considering those things outside of the indictment absolutely transforms that into a speaking demur. It's void, it can't be granted. If you look at the counts, the forgery counts, they track exactly the forgery statute. Case law tells us that that's what's sufficient for a general demur. I don't know that there's anything else to say about those counts. As it relates to the false statements, again, address that at the very beginning, but I would point out that in Haley, where both the conviction was upheld and the indictment itself was approved of, the indictment said this on the false statements counts. It said that the defendant did knowingly and willfully make a false and fictitious statement and representation in a matter within the jurisdiction of the GBI, a governmental agency, by calling himself the Catch Me Killer and stating that he killed 16 people. It doesn't allege any of the things that Mr. Shafer says in his pleadings that have to be alleged. They don't have to be alleged. Like they've done in other motions, defendant here is trying to add elements to this offense that just don't exist, trying to add pleading requirements that don't exist. And Haley tells us the case itself directly quotes the indictment. That indictment alleges far less than what we allege in our indictment. And they said that the Georgia Supreme Court said that case is just fine. I don't think that Mr. Gillen addressed the filing false documents motion. I believe in the pleadings, they state that those counts are flawed because they fail to allege that the filing of the false documents didn't succeed. Again, that's not a requirement in an attempt charge. And they also say that the counts don't say who actually attempted to place documents in a mailbox. The way that we've charged the count, we've charged all of those defendants individually and as persons concerned in the commission of a crime. And so it'll be for the jury to determine if all the defendants are liable for what one of their co-conspirators did. With that, I'll take any questions that the court might have.
Thank you, Mr. Wooten.
Thank you.
Okay, so Mr. Gillen, your last motion we had for today.
I have like
Oh, sure.
60 seconds.
Sure, have at it.
The state did not and cannot answer the direct question about a violation of the safe harbor rule, why that would allow that situation to give the governor or the Secretary of State any authority to do anything. That comes in under several of the arguments that we've made. I won't repeat it, but they simply, their argument is, let's put an agent up and ask the agent whether or not he had authority. No. By law, by federal law, they did not have the authority. It's not whether some GBI agent thinks that he can come in here and tell the jury, pay no attention to federal law, pay no attention to the dissenting opinion in Bush v. Gore, pay no attention to that. I'm a GBI agent. I say we can do it. That's wrong. They lose there because the law is very, very, very clear. And we can go back and we'll, both the state and I know the Shafer team will go back to look at our argument that we made to the court when my recollection could be wrong. But I don't think so. We'll see. But my recollection was because the pleading was a part of the court system that we had a citation which permitted the court to take that into consideration as part of the record and thus not going outside of the record for speaking demur. I could be wrong, but we'll get that to you quickly because that, and they latch onto that to say, pay no attention to the reality of what happened in this courthouse, in the court filings, which destroys their argument. And so with that, Your Honor, I'll sit down and then I'll go back and get my other folder.
So in your last motion here, I'm kind of as we were with the First Amendment issue, I think we need to figure out where we are procedurally. Federally, it sounds like, this would be a pretty common motion. It'd be a surplusage motion. Georgia, it's not quite as clear for us. So, excuse me. Let's start with just the authority to kind of take a scalpel to an indictment and cut out things we don't like.
Well, I mean, Your Honor, we talk about, there are two components to this motion. One, there's the strike surplusage, and then there's a dismissal that we asked for, which is kind of also a component of the other. Now, we cite the state v. Corin on the issue of being able to, the allegation, the indictment is not wholly unnecessary to constitute an offense as mere surplusage. We think.
Right. But when we read the surplusage opinions, we're talking about, a miscited code section or a wrong date or something like that. So I don't know. I don't think that's what you're characterizing.
No,
as.
I guess this is where I'm.
It's more just a legal conclusion, right?
Let me, a legal conclusion, number one, but it's even more than that. It's this. When they continually in their pleadings, in the indictment, in their pleadings, in their extrajudicial comments that they make, they have bombarded the defendants, the electors in this case, with the concept of, and the phrase of fake electors. Now that is not, that is a description, a conclusion, and a pejorative description.
So it's a legal conclusion you very much disagree with. It's the core of your defense.
I think it's not only a legal conclusion, but it's also something that should be stricken because it is just a pejorative statement. I'm not saying, I'm saying, I can call you something really nasty in an indictment, and it doesn't necessarily have to be a legal conclusion about your violation of a particular law. And so that's what we have here. And we have this permeating this case.
Well, I'm just trying to, again, based on what we've seen and is allowable in Georgia, let's just make it simpler. If in a murder indictment, someone's alleged to have acted with malice aforethought, that's a legal conclusion.
Well, that's right.
And it's something that the defendant may really have an issue with, but we don't strike it. We just go forward and we go to trial.
Different world, different cases, not the point that I'm trying to make. The point I'm trying to make is, and you put in malice aforethought because you put that in there to
It's
define
essential
the
element, sure.
terms.
What about this one? There's one I remember when we talk about nicknames and aliases. And I remember there's one in Georgia from the 90s. They put in an alias of Stomper, and he had beat the defendant to death.
Well,
And the Supreme Court said, that's okay.
you know why? Because they probably proved that there was an alias of that guy called Stomper. That's different than
At
that's,
trial. The state's saying we're going to prove that you're
well,
an
I think,
unlawful elector.
well, no,
whatever they want to
no.
characterize it.
In this indictment, what they have done in the indictment, it's not necessary for, if they want to, and we think it should be stricken, we think the count should be dismissed. We know that based upon the case law that we've cited. But in closing arguments, Lord forbid we ever get to closing arguments, hope we don't. But if we did, and they stood up and they said, well, we think that they were that we think the evidence shows that they were fake electors. That's one thing. That's argument. That's advocacy. There's no place for it in the indictment. And there's no place for it in what they have done, not only in the indictment, but in their pleadings and statements they've made outside to the media. What they have tried to do is they want to have ingrained in the minds of the community and of jurors a concept that if you were not a Democratic elector on December the 14th, casting your vote at some other part of the state capitol, then you are a fake elector. And that is a pejorative term, not necessary for the charges, and should be stricken. That's the point that we're trying to make. And as it relates to our other arguments concerning the dismissal of those counts, I don't think I need to go back over most of my argument, or our argument on that really deals with the Electoral Count Act. So I don't think I need to revisit that in case the court
We'll get there.
really wants to hear that again. I don't think you do. But absent that, Your Honor, we think, number one, that the count should be dismissed. The reasons articulated earlier and in our pleading. And number two, that even if the counts are dismissed, in addition to that, references throughout the indictment to fake electors should be stricken as well. Thank you, Your Honor.
All right. Thank you, Mr. Gillen.
Judge, I'll be brief. Nowhere in this indictment is the phrase fake elector. It does not exist. Literally not in the indictment. So I'm not really sure what we're talking about, removing something from the indictment that's not there. As the court pointed out, and I struggle with this motion, and I'm not going to say much because we're primarily relying on our response, but an indictment is itself a legal conclusion. Every allegation in an indictment is a legal conclusion. That's what an allegation is. And so if indictments aren't allowed to have legal conclusions, then I guess we aren't allowed to have indictments anymore. Judge, I think what the defense's strategy is here, and I know it's their strategy because they ask for it in the motion. They say, Judge, you should strike this language from these counts because we don't like it. It's not fair. It's pejorative, whatever reason. And now that you've stricken it, the counts don't charge a crime anymore. So you should dismiss them because they don't charge a crime anymore. That's nonsensical. We cite in our briefs opinions where the court says, the appellate court said, you literally can't do that. If something's essential to the charge, if it's essential to pleading an essential element of the charge, you can't strike it. It's not subject to being stricken. And I just highlight one citation that we reference in our brief, Malloy versus the state, 293 Georgia 350 2013 Supreme Court case. And that case says that when language in an indictment accurately describes the offenses charged and makes them easier to understand or more easily understood, they're not subject to being stricken because they're not surplusage. And that in making that in analyzing language in an indictment, in this context, Malloy also says that the language is to be interpreted liberally in favor of the state. And so with that, again, we rely on our pleadings. The phrase fake elector does not exist in this indictment. Take any questions that the court may have, but otherwise, nothing further.
Maybe one. I've seen a line of cases talking about whether defects, can be stricken, and a lot of that depended on whether they're material or non-material. Is it safe to say that these phrases, the ones that are highlighted here, lawful elector votes, false electoral college votes, and duly elected and qualified presidential electors, would you say those are material phrases for each of the charges they appear in?
So I think that's a great question, and I think there's kind of a superficial answer and then maybe a more in-depth answer. My superficial answer is yes, they're material, in the sense that they make the charges more easily understood. They're accurate, describe the charges. I am familiar with that line of cases, and it's a little bit unclear in the cases whether material means that or whether material means that, you strike something from the indictment that the count falls apart.
Sure.
So I'm not clear. What I know is in this context, I don't think it matters because what's being challenged, I think that it's approved of by our appellate decision.
If you've happened to go down that road though, and we take the position that material means it can still survive general demur. Any thoughts there?
Judge, again, turning back to Malloy, the holding in Malloy is that as long as the language in an indictment, even if it's not essential to an essential element, as long as it's accurate, it describes the offense's charge, and it makes it more easy to understand, it's simply not surplusage. If it's not surplusage, it's not subject to being stricken.
But do we think these phrases are material and meaning they're necessary to survive a general demur? I don't have them in front of me, so
I don't either,
Okay.
and so I hesitate to give an answer without the indictment in front of me.
that's fine.
You know, again, as long as the charges track the statute, they survive a general demur. So anything that's not statutory language, I guess, wouldn't fall into that category. But then we get into special demur territory, and that's a whole different situation.
All right. Fair enough.
Thank you, Judge.
Okay. Thank you all. Anything else we should, or matters of housekeeping, anything else we need to take up before we break? Anything from the state?
Nothing from the state, Your Honor.
All right. Thank you, Ms. Young. Anything from either counsel? Okay. Then we'll be adjourned. Thank you.
Thank you, Judge.
Play baseball now, I suppose. So we're headed to play baseball with our team now, I suppose, since we got everybody here. Who's the cleanup? I'll write it down for you. I actually don't have a business. Can I have one of your toast it? Will? Yeah.
I've never had you ask.
Love this video? Make sure you stay up to date on the latest breaking news and all things Midas by signing up to the Midas Touch newsletter at MidasTouch.com/newsletter.